Well, a very good afternoon, everyone, and welcome to the 2020 in-house community eCongress Vietnam. It's wonderful to have you all online with us. We'd love to have been in the same room at a nice hotel in Ho Chi Minh City or Hanoi, greeting each other, shaking hands, and all those things that we usually do at an in-house Congress event. But the world has taken a different turn this year, and so here we are online. But it's wonderful to have you all here, and we have the added bonus of having people not just in Vietnam, but around the world joining us online today. It's my pleasure now to instigate our second session for this afternoon, which is being brought to us by our friends at the Korean law firm Yoon and Yang. And as many of you know, Yoon and Yang have been very supportive of the in-house community in Vietnam for the last few years and spoken up the last few Vietnam in-house Congress events. And this afternoon, they're going to be presenting on debt financing. And starting with Mr. Hoon Cha, who has spoken at the Vietnam In-House Congress in the past. He's a partner and the Southeast Asia practice head at Yoon and Yang. And Ji-Hoon's main practice areas include overseas investments, international finance, and international dispute resolution and international mediation. And Ji-Hoon this afternoon will also be joined by Harty Tinh, who's a Vietnamese attorney who has also spoken at the Vietnam In-House Congress events before. She's based in the firm's Hanoi office and has been handling matters involving M&A, corporate restructuring, international JVs, project financing, and commercial issues. So thank you to both, and over to you first, Ji-Hoon.
Thank you, Tim. Good afternoon, everybody. I'm Ji-Hoon Cha from Yoon and Yang. We are planning to present the debt financing, and we plan to give the presentation about the types and structure of the loan and the terms and conditions, and the restrictions and regulations under the Vietnamese law, and lastly, issuance of bond. But unfortunately, when I calculate my time, I realized that I have to skip the first part of our presentation. Types and structure of the loan should be skipped due to the time limit. So I'd like to start from the second part, terms and conditions of the loan. You can easily understand the types and structures of the loan when you see our presentation material. So let's start from the terms and conditions of the loan, the second part.
Ji-Hoon, this is Tim. I'm just going to jump in and say, please don't feel under too much time pressure. If we run 5 minutes over, that's not a problem at all. So don't feel under too much time pressure.
Okay, thank you very much. Anyway, yeah. So anyway, let's start from the terms and conditions of the loan. I'll give my presentation based on the syndicated term loans. First, you have to understand what is the facility. Facility means that the lending the money to the borrower by the lenders. It means that loan itself. So a facility composed of the commitment of the lenders. When you loan agreement, when you see the loan agreement, you can see the commitment of the each lenders at the end of the loan agreement in the schedule, as attached here this slide. And in the syndication loan, there are several lenders. So the obligation of the each lenders are several under the syndication loan. So it means that even though one lender fails to perform its extension of the loan committed, the other lenders has no obligation to extend the loans beyond the loan amount they committed itself. So under the syndication loan, you need to understand each obligation of the lenders is several. And because lenders incurs the cost to keep their commitment to extend the loan, the commitment of the lenders usually has the availability period. It means that every loan under the loan agreement should be drawn down within a certain period agreed by the each parties. If the borrower pays to withdraw the loan within this available period, the loan and the commitment of the lender will not the valid. And the purpose of the loan. Lenders usually limit the purpose of the loan. And if the borrower use the loan other than the purpose which was agreed under the loan agreement, this misuse of the loan will compose event of default. So the borrower should be very careful to provide the purpose of the loan. So let's take an example. Lenders, the borrower has the multi-purpose of the loan to provide a loan to purchase the machinery, or to build the factory, or to provide the working capital. If the borrower has multi-purpose, to have the loan, in the case, the tranche should be used. In each tranche, even though the parties are same, each tranche will be separate each other. So the multi-purpose can be separated in each tranches. And let's move on the conditions present. Before the borrower draw down the loan, all conditions present should be satisfied. Lenders always concerned about the safety and effectiveness of a loan agreement, and always concerned whether their loan will be securely repaid or not. So the lenders usually, before they enter into loan agreement, makes the due diligence. And based on this due diligence, lenders require the borrowers to provide some the document which shows that this loan agreement would be safe and effective. The typical conditions present compose the borrower's documents, such as the articles of association of the borrower, or IRC or ERC, deed of establishment of the borrower. And also board of resolution, and sometimes shareholder resolution would be required as the conditions are present. And also the financial statement of the borrower should be submitted before the borrower draw down the loan. And other than these borrower's documents, all finance documents such as loan agreement and the intercreditors agreement or P letter, this kind of all the document should be executed by the parties. And if the loan is secured by the security, also security document should be executed, such as mortgage agreement or the guarantee letter should be executed before the borrower draw down the loan. And also, if loan requires the government approval, such as the mid-term or long-term foreign loans requires registration of the state bank under the Vietnamese law. So if the borrower get the foreign loan, government registration to the state bank of this loan should be the conditions precedent. And the lenders requires borrower's counsel to provide a legal opinion regarding the loan transaction is effective and legitimate and also enforceable. So I have the experience when we are required to provide our legal opinion as the borrower's the counsel to the international the lenders. Usually, the international loan transaction loan agreement has the governing law in the foreign country. Usually, the English laws will be the governing law, or the country lenders the country law will be the governing law. And in the case, the lenders insist dispute resolution body should be English court, and asked the borrower counsel to provide this English court decision would be impossible under the Vietnamese law. But as you may know, under the Vietnamese law, foreign court decision would not be impossible in some cases. So it was very difficult for us to persuade the lenders to change the dispute resolution bodies other than English court. So when you engage in international transaction, you should be also very careful about the providing the legal opinion about the enforcement of the loan documents. And after all conditions present are satisfied, then the lenders can utilize the loan by submitting the utilization request to the lenders. And let's move on terms of the repayment. On the maturity date, the borrower shall repay the whole loans. And under the term loan, if the borrower repay part or whole the loan amount, that amount should not be reborrowed by the borrower. This is the definition of the term loan. But if you engaged in revolving loan or overdraft loan, you can reborrow the amount which was repaid by the borrower within a certain period. So that's the difference between term loans and revolving loan. One thing you should note that between the international practice, loan practice, and the Vietnamese law is that the application order. Under the general practice of the international loan transaction, the application order is the first, the payment will apply to a cost of the loan and the interest, and lastly to the principal, applied to the principal. But the Vietnamese law provide that the partial payment should first apply to a principal and then interest and the cost. So this makes a big difference between international loan practice and the Vietnamese law. So we are asked whether this Vietnamese law is mandatory, means that the parties cannot change the order of the application under the Vietnamese law or not. Because the Vietnamese law is not clear about this issue. As Ms. Tinh, my colleague, will give you the further explanation. But the expert opinion, lawyer's opinion is split on this issue. But I recommend for the safe way not to the conflict with the Vietnamese law. Let's move on the prepayment and cancellation. Sometimes before the maturity date, the borrowers should mandatorily should prepay the loans, or the commitment should be cancelled before the availability period. For example, if the loan transaction becomes illegal due to certain reason, the loan cannot remain effective. In that case, the borrower is required to prepay all loan amount extended to the borrower, and commitment, which has to be withdrawn by the borrower, shall be cancelled. So this is the so-called mandatory prepayment or cancellation of the commitment. And if change of the control of the borrower happens, this mandatory prepayment and cancellation also apply to the change of in case of change of control, because the loan is extended by the lenders to the borrower based on the credit line of the borrower. So lender consider the change of the borrower's shareholder composition would affect the line of credit of the borrower. So in the case, the lender require the borrower to prepay all the loans, or shall cancel the remaining commitment. So and sometimes borrower want to voluntarily prepay its loans, or want to cancel the remaining the commitments. Because they find out another the funding resource which is more favorable to the borrower. They want to replace existing loan with the more favorable the funding resource. So in that case, the borrower want to voluntarily prepay the loans. Usually, the lenders under the international loan transaction allow the kind of prepayment or cancellation of the commitment, but they usually levy the prepayment the fee to the borrower, and will limit the minimum amount of the prepayment of the loan. So as the borrower counsel should negotiate with the lenders about that prepayment fee and or the minimum amount of the prepayment. Let's move on to interest, slide number 19. The calculation of the interest. Usually interest composed of the margin and the basic, the cost such as LIBOR or JIBOR. The issue is that regarding the interest period is whether the borrowers shall pay the interest for the interest period. For example, if the interest 3 months in year, the interest period would be the 3 months. One issue is that whether the first date of the interest period will include into the to the interest period or not, or last date of the interest period would be included or not. The another general international loan transaction practice, the first date of the interest period will not include to the interest period, but last date of the interest period will include. So if you pay the interest, you have to be very careful to calculate the date of the interest period, because the interest will be paid based on the date date of the terms. And let's move on to payment of the interest. If the interest shall be paid in lieu, the last date of the interest period, the borrower shall pay the interest. One thing should be noted is that compound interest. Usually, international lenders require the compound interest. Compound interest means that interest on interest. If the lender fails to pay interest, the interest rate will incur on the interest itself. But it is a little bit unclear whether this compound interest would be allowed under the Vietnamese law. Again, because the law is not unclear, not clear, the lawyers' opinion are split on this issue. So again, I'd like to recommend the safest way, not to take compound interest on your loan agreement. And actually, this would be for the beneficial for the borrower. And default interest. If the borrower failed to pay some amount which is due, the borrower shall pay the default interest, which is different from the interest. And interest rate also different. But what you should note that under the Vietnamese law, the maximum default interest is limited up to 150% of the interest rate. This is also sometimes cause some problem with the international lenders, because usually international lenders the levy on the higher the default interest rate compared with the 100% of the interest rate. So you are frequently asked whether this the Vietnamese law is mandatory or not. I think at least this the Vietnamese law regarding the maximum rate of the default interest would be mandatory. So should be complied with the Vietnamese law. And let's move on the tax close-up clause. because the lenders get the interest, and interest earning is subject to the tax. But the lenders usually require the borrowers to add up their payment as if there is no tax deduction. So it means that the borrower shall bear another burden about the tax. So when you engaged in international loan practice, you should check the double taxation treaty with the lender's country. If under the double taxation agreement, the withholding tax regarding the interest is significant, you need to understand how much the borrower shall bear the cost under the tax growth of the course. Let's move on to representations of warranties. The lenders require a borrower to give the representations or warranties to secure the loans. The borrowers shall give the good standing as the corporate status, and the obligations are all bound, and they are not a conflict with other obligations, and the borrower have the power and authority to enter into this loan agreement. There are many other items under the representations warranties. Let's just explain about the pari-passu ranking, which is very unique under the loan agreement. Pari-passu ranking means that the lenders under the loan agreement are equally treated in its preference to other creditors of the borrower. So at least the borrower, which is not secured by the security, will not subject to subordinate loan. Instead, should be equal to other unsecured creditors. And these representation warranties should be repeated. Some of the representations and warranties should be repeated whenever the borrower draw down each loans. Let's move on to undertakings. This is the obligation of the borrower. Borrower should provide informations such as the financial statement or compliance certificates, or if default happens, regarding the notification of the defaults. And also the lenders, because all lenders are required to comply with the non-money laundering the regulations. All lenders require know your customer checks information. And the financial covenant, because lenders extend the loan based on the credit line of the borrower and want to maintain that the credit line, so required borrower to maintain certain ratio of the credit indicators. This shows one example of the financial covenants. And general undertaking. Other than these information undertakings and financial covenants, lenders usually require other the general undertakings. authorization, borrower shall keep the license and other government authorization, and also comply with the law during the term of the loans. This is the general undertakings. What the borrower counsel should be careful about the loan transaction is that negative the pledge or no disposal or acquisition, which affects significantly on the borrower's the management of the business. Could you move on to slide number 25? This negative the pledge, such as the lenders will prohibit the borrowers to provide their asset to the security, or to prohibit to dispose of their assets, or even acquire other companies. This kind of restrictions will affect the significantly the operation of the borrower's business. So the borrower should be very careful where regarding the borrower will accept this kind of undertakings or not. And sometimes borrower may suggest some threshold, such as the value of the certain amount of the value only will apply to this the negative pledge or other general undertakings. Lastly, let's see about the event of default. The event of defaults composed of the non-payment of the borrower and other obligation, the breach of the other obligation, or borrower's misrepresentation and other things. Let me explain about the cross defaults. Cross defaults means that even though the borrower still comply with the obligation or all obligation under the specific loan agreement, if this the borrower failed to perform the payment obligation under the other loan agreement or other agreement, in that case, even though that default under the other agreement composed of the default in the this agreement, so it is the sort of the cross default. It cross defaults also trigger the acceleration under the event of default clause. Also, the borrower suggests sort of the threshold, which amount of the cross default will trigger the event of the default. And lastly, what happened if the event of default arise? If the event of default arise, the loan, the payment obligation of the loan of the borrower should be accelerated, and under the certain the event of default, the acceleration should be proceeded automatically, but generally the lenders will give the grace period to fix the default. So as the borrower counsel, you have to be very careful what event of default would trigger automatic acceleration, and what under what event of default borrower will be given the grace period. So I gave you the general description of the terms of the conditions of the international loan practice. As you know that so there are some the differences between international loan practices and the Vietnamese law. So you have to be very careful about what makes the differences and what you have to be prepared when you negotiate with the lenders. And my colleague, Ms. Tinh from Hanoi office, will give you the further the presentation about the restrictions and the regulation of the loan the transaction under the Vietnamese law, and also the issuance of the bond. Thank you. Tinh, could you take your part?
Yeah, I'm doing. Yeah, hi everyone. My name is Tinh. I'm from Hanoi office. I have joined Yoon for more than 3 years, and most of the time I have participated in this in-house virtual congress. This is the first time for me. So nice to meet you again. And because the time limited, so my parts will include two sections. The first one is relating to the restriction and regulation, and the second one is issuance of bonds. But I don't think that we have enough time to do the presentation for the issuance of the bonds. So I'm only going to focus on the restriction and regulation under the Vietnamese law. I cannot move my PPT. So the first thing is relating to the loan agreement. Under the circular 39, loan agreements must be made in the form of written contracts and at least containing of the following contents: the name of the party, the amount of loans, loan use purpose, loan currency and repayment currency, lending methods, loan term, interest rate, drawdowns on loan capital and use of payment means to draw down loan capital, repayments of the principal and interest, and the priority to recover the principal and interest, early payments, restructure of the loan payment term, conversions to overdue debt of the principal, responsibility of the borrowers, termination and early recovery of principal and interest, and processing of loan debt, fine for breach, compensation, payable for loss and damages, and rights and responsibility of the party, and also the effectiveness. And the restrictions of the loan use purpose shall include the credit institutions only allowed to lending for the following purpose: like financing for investment activity, transactions, goods and services which are not prohibited under the law, purchasing the loan for repay of finance debt made by credit institution itself, repayment of loan made by another credit institution, or to repay the foreign loans, except for the loans to make early repayments of the loan which satisfies all the following conditions. The first thing is loan to serve the business services. The term of new loans do not exceed the current term of the current loans, and the term for the repayments of the loans have not been restructured yet. The language to be used in the loan agreements, it must be in Vietnamese, and sometimes it can be in Vietnamese or bilingual between Vietnamese and foreign language. The condition for providing the loan: the credit institutions only can provide a loan for the person who satisfies the following condition. The first condition for the organizations, they must have a legal capacity under the Vietnamese law. For the individuals must be 18 years old or more, and with full capacity for the civil acts. And the loan use purpose must be lawful. They should have the feasible capital utilization plan. They should having the financial capacity to repay the loan and having the transparency and healthy financial status. The currency to be used in the loan can be in Vietnamese or foreign currency in accordance with the provision of law. And the currency to use for repayments of a loan shall be in the currency of the loan. I want to discuss about limitation of the interest rates and the default interest rates. For lenders who are not credit institutions, the CV code shall apply in this case. The specific interest rate shall be when the party agree on an interest rate, the interest rate cannot exceed 20% per annum. When the party fail to agree on a specific interest rate and having a dispute, the interest rate shall be 10% per annum. For default interest rates for the principal is 150% of the loan interest unless otherwise agreed by the party. For default interest rates for interest is 10% per annum. For lenders who are credit institutions, in this case, the Circular 39 and other regulations issued by State Bank from time to time shall be applied. The credit institution and its client, in principle, can reach an agreement on the loan interest rate depending on the market supply and depending on the capital, the amount of loan, and the credit rating of the borrower. At the present, the interest rates for Vietnam Đồng in the short term being used for certain business activity, it shall not exceed 5% per annum. For default interest rate shall not exceed 100% of the interest rates, and the default interest rates for the interest cannot be exceed 10% per annum. For lenders outside Vietnam, the lender and its client can choose the governing law, either Vietnamese law or the foreign country law. Even if the foreign loan agreements apply the law of the foreign countries, the State Bank of Vietnam sometimes may be very concerned to get into the interest rates, and because for foreign loans, it's required to register with the State Bank, which I will discuss in the next slide. The foreign loan will be required for registrations if the foreign loan for minimum and long-term loan. The minimum loan is about how much, and the foreign short-term loans would have been extended, and the total loan term is about 1 year. Depending on the total value of the loan amount, the registrations required can be submitted at the State Bank of Vietnam or the branch of the State Bank in each province, where the head office of the borrower registered. The purpose of the loan for the foreign loans, the borrower are permitted to borrow loans to only serve the following objective: to implement the business and production plans or investment projects, or to restructure of foreign loan debt of the borrower without increasing the cost of the borrowing. And the currency to be used in the loan must be in foreign currency. The Vietnamese currency will be used only if the foreign loans given to the microfinance organization, the loan between the foreign investor in an invested company and such foreign invested company, or some cases or specific cases will be approved by the SB, by the State Bank of Vietnam. The condition for repayment of and disbursement. The repayments and disbursement of the foreign loans of Vietnam borrower being the foreign invested company must be met through VCACA. For the borrowers who is the Vietnamese legal entity, who is not the foreign invested company, so can be met to the payment account. Some notable points regarding to foreign loan agreements. The language. is different from the loan agreement in the domestic. The foreign loan agreements can be made in foreign language. However, for the purpose of registrations, the loan agreements must be translated into Vietnamese with the certification of the notary office and submit to the state bank. For the governing law, even if the foreign loan agreement can apply the foreign law, however, such foreign loan agreements must not be contradictory to the Vietnamese law and must sign prior to the rollout. I will discuss about some restrictions on the issue provided by non-credit institutions. For the methods, the restriction on the method of lending and repayments. So in the lendings and repayments, that is not permitted to make in cash. It's not made by bank transfer or other kind of non-cash payments. For the security measures, if the borrowers are being organizations, they are not allowed to acknowledge the land due rights and the access to the land in order to secure the loan provided by non-creditor. The restrictions on the loan, on the provision of loan for non-credit institution is not allowed to provide a loan frequently and oftenly. If the non-credit institution provide a loan frequently, then that non-credit institution shall consider providing loan is one of their business activity. So in that case, they must establish a subsidiary or they must amend their business line to provide the credit extension, and they must apply for the license of establishment and operation of non-banking credit institution under the circular of the State Bank. Excuse me, do we have more time? No.
Hello. Yes, you certainly can take 5 or 6 more minutes. No problem.
Because I have another section to go, issuance of bonds. But I think that I should close my presentation by comparisons, because issuance of bonds is also another kind of loan, but it will be issued by the specific procedure. So in comparison with the comparison for the characteristics between credit compared to the issuance bonds and the loan. So the natures of both loan and the loan are the methods of the capital mobilizations. The bondholders is similar to the lenders, and the bond issuer is similar to the borrowers, and the bond coupon is similar to the loan interest. So the difference between the loan itself and the issuance of the bond is that indicate the restriction of eligibility. So the bond issuer must satisfy a lot of conditions, which are which compare more strict than the normal lenders. In regard to the implementation plan, while the plan for mobilizations of the loan is decided by the enterprise, the land for bond issue must consult with the eligibility consultants. In regard of the state managements, the bond issuer must implement the procedure to the government on the information disclosure, registration, exploratories of bond reports, and from the commission of issuance change until the maturity of the bond. In regard to the feasibility of assignment, except for the requirements on 1 year lockup periods, it is easier for the bondholder to transfer the bond in comparison with the loan transfer, which a lender may want to implement due to the development of the market and the bond transfer from time to time. So I think that's all my presentation. So I'm waiting for your question. Due to the time limited, so some part regarding to the bond issuance I cannot present with you today. So it's my pleasure to answer any question. Thank you.
Excellent. Well, thank you both very much. You covered a great deal there, and I'm glad, Tinh, you continued on to talk about bonds, because we actually had a question about that and we're asking for more information on the issuance of bonds. So I'm glad you were able to cover that in. Can I ask, will you be happy to people to contact you for a copy of these slides? Because I know there's requests for that. Will you be happy to share these slides with our attendees?
Yes, you can. Everybody can share this slide because I skipped my presentation material. So this presentation material would be helpful to further understand of my presentation.
Excellent, excellent. Well, thank you very much. So what I'll say to everyone is, obviously, thank you very much to Yoon and Yang and for Hoon and Tinh for the presentation. They'd love to hear from you. And if you have further questions or you'd like a copy of these slides, please do contact them. We'll make their contact details available after this session. But I know they'd love to hear from you, whether you're in Vietnam or whether you're outside of the country. And I'm sure they'd be very happy to assist you. And if you've got further information on a copy of these slides, please do get directly in touch with them. Now, we do have a question come through, and my colleague Raoul was going to share it with me. I should move my glasses down my nose so I can read it. And it's to Ms. Tinh regarding the foreign shareholder loan. If part of such a loan is repaid, is the remaining required to register or re-seek the approval from the SBV?
As I discussed before, that is depending on the term, the loan term. So if it's this 12 months, if it's more than 12 months, then it must register with the State Bank of Vietnam. And it depends on the amount of loans. So you may register with the governmental State Bank of Vietnam or its branches located in each province.
Excellent, thank you. Well, thank you very much.